We're going to be discussing all the dangerous questions that you will be asked during your workers' compensation hearings and trials. These are questions that have the potential to reduce your benefits or have your case denied, disallowed, and thrown out altogether. So it's very important as to how you answer your questions when you're asked them under oath during a hearing or a trial. As a bonus, at the end, I have some special tips on what you need to be reminded of. These are my pro tips, special tips, things that you need to keep in mind when it's time for you to answer questions in front of a law judge. So which questions during your workers' compensation hearing, and more importantly, your trial, are the most dangerous? Which ones have the greatest potential to reduce or deny your case? Okay, you got to be careful anytime any question is asked. Every question that is posed to you is asked for a reason. Circumstances surrounding your injury. If there are any inconsistencies between how you respond at the time of a hearing or a trial and previous reports, whether it's medical reports, injury reports, accident reports, email to your boss about how the accident happened, those inconsistencies will be used to challenge your credibility and the credibility of your claim. So keep in mind, what type of history, what type of notice did you give about your accident? When you're asked that in front of a judge, it better be pretty close, because if it's not, they're going to say, well, you gave two different accident histories here. And it happens a lot. And oftentimes when you get the whole story, it all comes together. But let's get ahead of that. I don't want an insurance company attorney alleging that my client gave conflicting histories of an injury. Try to be consistent with the history, okay? This also includes questions about the timing of your claim. What time did your accident happen? What time did you go to the hospital? What time did you give notice? If you don't know the specific timing, don't guess. Employment history and job duties. This information could uncover prior injuries or conditions that played a role in your current injury. Okay, so you want to be consistent about your employment history, your job duties, your past job duties, your past employment, and past injuries. You want to be upfront, honest, and credible, and you want all of your histories to be the same. Similarly, and we just touched on it, pre-existing conditions. An insurance company might use this information to claim that your current injury is just an exacerbation of an old injury. This could get them off the hook. They could say you didn't really get hurt this time. This is just a flare-up of an old injury with a different insurance company, and let them pay for it. Well, maybe yes and maybe no. Insurance companies are looking to avoid liability, and they don't want to have to pay. The other thing is, if you hurt that same body part 5 years ago, well, there's a strong argument to be made that your current level of disability is not entirely due to this accident. It's only partially due to this accident and partially due to the old accident. But the other aspect that you really need to remain conscious of, it also calls your credibility into question. If you deny that you hurt your shoulder 3 years ago, and it turns out that you did and you had surgery, and you act like nothing ever happened, your credibility just got blown up, and you're going to look terrible in front of a judge. Now you look like a big liar, and we don't ever want you to look like a big liar. So you need to be consistent, you need to be upfront and honest, and you need to get out in front of your questions. Other things like following your doctor's medical instructions. If they find you're not following your doctor's medical advice, you're missing appointments, you're missing treatment, they're going to use it to argue that you're not serious about your recovery, you're not serious about your claim. They're going to use it to make you look bad. Similarly, if they find that you have big gaps in your treatment, they're going to make the same arguments. So see your doctors consistently and follow your doctor's instructions. Other things, activities outside of work. Performing activities that don't match up with your reported injury and your limitations will call your credibility into question, and it could turn into a fraud. You know, if your doctor says that you're not able to lift more than 5 pounds, you're not able to walk more than a half a city block, and they have you shoveling snow and doing your neighbor's house because you're a good guy, they have that on surveillance. They're going to use that against you. So you need to be careful what you do outside of work. Other things, your reported pain levels and your symptoms. If your pain levels and your symptoms don't match up with the medical evidence or what others observe, it can lead to doubts about your level of disability and the viability of your claim in general. So be conscious of all this stuff. The attorneys for the insurance company are the judges, so you should as well. So all these things that we just discussed are all going to be used by the carrier to call your credibility into question. And if they're egregious enough, they're going to raise fraud against you. And it puts a black mark on your case once it's raised, and it's hard to get away from that, even if you didn't do anything wrong. So you really need to be very, very careful. What best practices should you follow when answering questions at your workers' compensation hearing or trial? Number one, never, never, never lie. By responding to questions in a certain way, you can limit the amount of information you give the insurance company, okay? You want to answer the question, and you only want to answer the question. Every now and again, somebody says, well, what should I say? What should you say? You say the truth, and that's it. And that's all I'm ever going to tell you to say. And if you ever say anything other than the truth, you're going to piss me off. So if I know that you're lying, we're going to have a major, major problem. Always tell the truth and answer the question that they're asking you. It's that simple. By answering just the question and not giving too much information, you can avoid having your words used against you. Be smart. Choose your answers carefully. For example, hedge your language if you're not sure. If you're not sure what the absolute answer is, you could say things to the best of my knowledge, to my recollection. My estimate is this. Sir, I'm not 100% sure, but I think, you can hedge a little bit. Don't use absolute language. Don't say I always do and I never do, unless it's absolutely true. Lawyers take things very literal. So if you say you always blank and I find one circumstance where you didn't blank when you should have blanked, I'm going to jump all over you and make you look like the biggest liar possible. So be very careful with the answers that you give. The majority of your answers should be as short, as brief as possible. That's it. Answer the question. Listen to the question. Take a minute, take a breath, take a pause, count to 4. It sounds like you're having a conversation, but you're not having a conversation. You're testifying under oath. So don't get into that rhythm of having a conversation, because that's where people get lost and they start volunteering information and they talk too much. And you want to reach over and say, don't talk too much. Okay. Volunteering information, it prevents the insurance company lawyer from discovering additional details that they're going to try to hammer you on. They're already trying to kill you. Don't give them more ammunition to do it. Okay. Don't try to guess where the line of questioning is going. We see it a lot. You want to show that you're not an idiot and you try to get ahead of the attorney asking you the question. Don't answer before they ask. It's okay if you look like you're not the smartest person in the room. You're testifying under oath. It's a whole different game. It's something that you're not accustomed to. So stop, listen, take a pause, think, and then answer just the question that they asked you. If we want more information, trust me, we're going to ask you for it. And remember, everything that you say is getting written down. If you don't understand a question, you can ask for clarification. Responding to a question that you don't entirely understand can result in you sharing more information than you intended to do so, okay? There's nothing wrong with asking a lawyer, I'm sorry, can you repeat yourself? Can you rephrase that question? I don't really understand it. And sometimes it's fine to just do it just to slow down the attorney's rhythm if he starts getting at you and hammering you. And if you need to break that, you could say, I'm sorry, can you rephrase that? Or I didn't understand your question. Can you ask it a different way? Nothing wrong with that. If you don't remember something, there's nothing wrong with saying, I don't know, or I don't remember. If you don't know, the answer is, I don't know, okay? And again, only answer the questions that you are asked. Do you know what time it is? The answer is yes or no. It's not 3:15. The question is, do you know what time it is? So think about what they're asking you and answer that question. If you do like what I'm telling you, please do not hesitate to hit the like button. It helps me. I'm just a guy who's trying to help people out, and it puts a smile on my face. Any final pro tips for injured workers with an upcoming workers' compensation hearing? What would you tell them if they were your clients? Whenever we have a trial, a hearing with a time allowance, whenever we know somebody's going to testify on ANCR or the initial issues surrounding their case, they're going to testify on LWEC or permanent disability and the vocational factors surrounding their permanency. If they're going to testify on, any other issue that requires in-depth testimony, we always call them, get them in for an appointment, and we prep them. This is the questions I'm going to ask. This is what I expect the insurance company to ask. This is how it's going to feel. I almost invariably run through a mini fake trial where I hammer questions and I try to get the person comfortable. So prep with your lawyer in advance. Review your case and your details and the details of your accident, your injury with your lawyer. Have your lawyer explain the process and discuss strategy so you know what to expect. You want to be comfortable. Not only is it being aware and taking a breath and thinking about the question and answering briefly, if you're not comfortable, none of those things will happen. Okay, make sure you're honest with your attorney up front so they don't get blindsided during the hearing also. It does happen from time to time that the insurance company breaks out the smoking gun piece of paper, the letters, something. If you know it's there, talk to your lawyer. Practice answering your questions with your lawyer so you feel comfortable and you know what they're going to say, you know how they're going to say it, you know what you're going to answer, and you can expect what the insurance company is going to answer. Also, if you're going to vent, if you're pissed and you want to vent and yell and scream, do it here in my office. Clients all the time will get agitated and get riled up and they say, all right, and they start yelling and screaming. And I tell them, if you're just blowing off steam, you can yell and scream all you want. Go for it. I'd rather you do it here than you do it in front of a judge. And unfortunately, not always the case. And I've had clients curse out the judge and yell and scream and get up, and you don't want to do any of that stuff. My attorney says it's not about being emotional. I don't disagree with that statement. The reason why you want a lawyer is because we avoid the emotion. I don't know your boss. I don't know how much of an a-hole your boss is, and I don't care. I'm here to take the facts of your case and take the law of this state and apply the two and get you the best outcome I can without being emotional. So yes, a lot of times it's not about being emotional. You want to take the emotion out of the game. And if you can, you want to use the emotion to your advantage, which means if we're in a controverted case that they're fighting and I get to cross-examine your boss or your supervisor or somebody from your company, I'm going to try to get him emotional or her and get something out of them that's going to hurt them. And they're going to try to do the same thing to you. I don't want you to get emotional. When the insurance company asks you, well, isn't it true you were late 4 out of 5 days the week before the accident and you got written up? They're trying to get you riled up and get you emotional. Well, that's BS. And no. You're not going to answer the question that way. You're going to say yes or no. And that's it. Okay. Less is more. You don't need to run your mouth. Your medical evidence shows how disabled you are. The fact that that you're walking with a cane shows how disabled you are. Sitting there and saying that I can't, and I tried to go to take my grandkids to the water park the other day. You can only go down the slide twice. Like, what? And you think I'm making a joke, but stuff like that comes out. Less is more. When the insurance company attorney is asking you a question, less is really more. If I'm going to ask you, my client, a question, I'm going to ask you a who, what, where, when, why question. How long did you work for this company before you got hurt? Well, I worked there for 3 years. And what were you doing at the time of the accident? Oh, I was building a cinder block wall. I'm asking you questions, open-ended questions. They're not yes or no questions. They'll result in a one-sentence answer. When the insurance company asks you a question, they're going to ask you yes and no questions unless they're bad lawyers. And they're going to ask them in a way where the yes that you're giving is going to make it sound like you did something wrong. And that's fine. If you answer it honestly, then your lawyer can go back and do what we call redirect examination, and we could rehabilitate. We could show why that question really was a BS question and what it really meant. But if you're not honest about them, then we're screwed. If anybody ever has any questions, please feel free to give me a call. My name is Rex Sikowski, 212-406-8989. Folks, have a wonderful day. Have a wonderful rest of your week. And again, if there's any questions, always feel free to give me a call. Have a wonderful day, everybody. Thanks.